Thank you, Josibel. Hello, everyone. Welcome to our webinar about ESG matters HR should focus on. My name is Sophie Maes. I'm an employment lawyer and a partner at the Belgian member firm of Jus Laboris, Kleijs and Engels, and it is my pleasure to host today's webinar about ESG in the workplace. ESG stands for environmental, social, and governance. It refers to evaluating a business not from a financial perspective, but from an environmental, social, and governance perspective. And I think we can all agree that businesses are increasingly expected to act in accordance to ESG standards, and this by various stakeholders. Think about investors, shareholders, customers, but also employees. And in particular, young employees, they really want to work in an environment that corresponds to their values. Besides social pressure, we also see governments around the world taking steps in order to force companies to think about ESG. And also the EU has been quite active the last years. Think about the whistleblowing directive, and now recently we also have we had a proposal in February about sustainability corporate due diligence. And I think these are all signals that companies and organizations must also consider ESG in their HR practices. And this is why we Jus Laboris are here for, because we want to assist you. And within our alliance, we have expert groups. We have 9 expert groups in total. And what we have done is that expert groups and the shares, they have asked their members some questions, some key questions HR should focus on in relation to ESG matters. And we have gathered all the responses. We had responses from many countries on a dedicated web page on our internet webpage. You can find the reference over there. And you find there the overviews of our surveys when you click a bit further, but also some other interesting material that we have prepared in relation to ESG. We had already, because today is our second part, we had already a first webinar about ESG where we discussed the outcome of 4 surveys that we have done. We have talked about ESG and bonus plans. We have talked about ESG in relation to health and safety standards, also impact on individual policies, etc., etc. If you're still interested in those, you can still find the recording on our website. But today we will discuss some the surveys that we have done with the 5 other groups. And it is my pleasure to introduce you to today's panel with our other expert group shares. So who do we have here today? We have Burkard. Burkard is from our German firm Klimt. He shares the restructuring group, and he had a look at ESG and co-determination rights. Then we also have Lucy number 1, because as you can see, we have 2 Lucys today. We have Lucy from our UK member firm Lewis Tilken, who shares our diversity and inclusion group. She will have a look at whether positive action can be used to promote diversity. Then we have Philip Nabben from our Dutch member firm Brandheidsdeur. He shares the privacy group and had a look at some questions in relation to privacy and ESG. Then we have Lucy number 2, also from the UK, but from our pension firm, and she had a look at ESG and impact in pension schemes. And then finally, we have Janusz from our Polish firm. He shares the internal investigations group, and he had a look at some questions in relation to ESG and internal investigation. So we are very happy with the speakers of today. So perhaps I can kick this off now first with Burkard. Burkard, you shares, as I said, shared the restructuring group. You had a look at ESG and impact on co-determination rights. So if you can share a bit, what are your insights, your findings based on the surveys that you have done? Thank you.
Sure. Thank you, Sophie. Thank you so much. Maybe to start with, this is an entirely new subject. And we have seen discussions on the co-determination side coming up in France in last summer with a new law passed by the French government, including ESG into the list of items that need to be covered on consultation process. We have seen first cases where ESG issues have been raised in restructurings in Germany over the time of the new year, January this year. And now we see ongoing discussions in a lot of jurisdictions on how to tackle the entire ESG discussion into a consultation process. Now, the consultation process can have two limits. One, of course, is where we are talking about entrepreneurial risks and the question on ESG ranking as a part of your refinancing activities, for example, in real restructuring cases, which are beyond the discussion that you would normally have with works councils or unions, because that's a shareholder discussion on the shareholders level with their banks and their financing institutions. On the other hand, you may have the question on whether the items that are up for change, the underlying restructuring, like your business plan, your business proposal going forward, is in line with general ESG considerations and thereby improves the company and the company's standing. We can easily see this if you look at the decarbonization side of energy companies these days, or if you go into the automotive industry and you see that large parts of their business may need to undergo a process from a energy point of view. We see spin-offs coming up and carve-outs for the reason of decarbonization. And there, for example, during the consultation process, we will see issues raised on whether a certain proposal that has been made will improve the company's standing from a decarbonization standpoint, for example. But this goes far beyond. We are expecting questions, if you look at the S, for example, in ESG, so the social part, we will see questions around supply chain and the treatment of suppliers. We will see things like human rights aspects and the whole Uber discussion coming in, Uberization discussion coming in, also under ESG criteria. The way this is going to work, most likely, is that the list of questions that will be discussed in consultation will simply be extended by standard questions on decarbonization, carbon footprint, on the energy supply, on the stability of supply chains, and on human rights aspects of certain proposals. We see them coming. This list, I've seen recent lists of about 10 to 15 items, so relatively small, but this is only the start of the discussion. So with France, Germany, and I think beyond. Now, why is this so critical? In the past, when we came up with a business proposal, we couldn't normally defend it. We would have checked it, maybe with business advisors, and we had to undergo a process. And by the end of the process, under most of our legal regimes, we were able to pursue with our project with some minor justifications, modifications, and maybe a discussion of certain alternatives. If your project can, however, be challenged from an ESG standpoint, on a political and communicative side, you're completely on the defensive side. So suddenly you're no longer in the driver's seat, but you may be purely in the defense. Because even though, from a corporate standpoint and a labor law standpoint, you may easily be able to defend your project and just go through the consultation process, you may just be hanged on communication, on political side, because it will be very easy to attack you like if you imagine in the situation of social media. To attack your whole program as being against all your values that you otherwise are communicating under ESG rules. And that's very, very dangerous. And that's why we believe, in a nutshell, Sophie, in preparing for this kind of consultation processes, we need to look into potential questions from the ESG side, see whether our project is in line with our ESG communication as such, whether we can be put on the defense side. And we will have to also balance this with some communication experts, because we may be challenged in public or on social media on these items. This is what we can tell you at the moment. So legal regime, yes. France, certainly. Germany coming. Other jurisdictions, we see discussions, but no legal framework yet. But this may only be a question of time. And I think by the end of this year, we will see this in the major jurisdictions in Germany, in Europe. Yeah.
Thank you, Burkard. Very interesting. Now, Lucy, moving to you, you're sharing diversity and inclusion. So one of the things you had a look at was whether positive action can be used to promote diversity. So what are your findings in terms of general trends around that?
Thanks, Sophie. And this is really interesting because obviously diversity is a really critical part of the S in ESG. It's often the first thing that businesses come to when they're thinking about S in ESG. And when we talk about positive action, what we're really talking about is how can businesses take steps to accelerate diversity? And there are lots and lots of good reasons for wanting to do that. You know, you talked a bit about consumers, investors. They all are looking at diversity. It's something they're taking into account when they're making decisions. Whether I buy from your brand, how diverse are you has an impact on that. Whether I invest in your company, diversity has an impact on that. And you know, we all know there's a post-pandemic war for talent. You talked about employees wanting to work in businesses where they're focused on ESG, and that really also means where they're focused on diversity. And so accelerating diversity, making your business more diverse more quickly has become a really, really critical thing for business leaders. And that's led to a focus on a positive action. And generally, I think it's important to say when we talk about positive action, we're generally talking about removing disadvantage or encouraging participation from underrepresented groups. That's something that's slightly different from positive discrimination. And positive discrimination broadly is where you're able to prefer a candidate from an underrepresented group, even if you don't necessarily think they're the best person, but because of the underrepresentation, you are able to prefer them for the role. And you know, across the globe, there's a distinction between positive action and positive discrimination, and pretty much everywhere, positive discrimination is unlawful. I'm going to say a bit about the UK because actually it's quite illustrative of the European approach to positive action, and actually it's pretty restrictive. So in the UK, like much of Europe, if, for example, you have a protected group, let's say women, people with disabilities, people from ethnic minorities, and they're not participating enough in an activity. In other words, they're not in certain types of roles. So you might not have enough women in STEM roles, or they are not in senior level roles. Then you can take proportionate steps to increase participation to remove disadvantage. But the UK position is really clear that you can't automatically prefer someone because of protected characteristics. As I said, that idea of positive discrimination. But what you can do, and this is the same actually across a number of European jurisdictions, you can have what we call a tiebreaker situation. So if you have two candidates for a role and they're of equal merit, then you can prefer one candidate from an underrepresented background if essentially that's the only basis on which you can make the decision. And that's quite interesting because in the UK, there have been some cases that look at that and say, well, what you can't do is essentially artificially lower, if you like, the pass mark or the benchmark. So you can say, well, look, everybody's equal, so we'll take through the people from the underrepresented groups, because in practice, they might all meet the benchmark, but in practice, of course, not everybody is equal. And although what we found from this survey is that the law isn't the same everywhere, the principles, particularly across Europe, are essentially the same. The focus is on increasing opportunities, removing disadvantage. So focusing on training and sponsorship, looking at how and where you advertise roles, as opposed to that idea of positive discrimination. A number of European countries like the UK have that idea of a tiebreaker provision. A smaller number have a sort of more permissive approach where you can have discussions with trade unions, and you can then submit positive action plans to local or national government to kind of have protection for things that might be on the edges of what would otherwise be permissible. But what we learned from the survey is that actually that isn't happening very much. And really interestingly, across Europe, there's very little case law on positive action. And in the UK, what's happening is that we're finding employers are actually starting to take a bit of a risk. They're doing things that are probably at the edges of what's legally permissible because they're so determined to accelerate the pace of diversity. They're willing to take a bit of a risk. Outside Europe, again, the position is pretty similar, very focused on positive action, not on positive discrimination. And really the position is the same. Again, a focus on training, sponsorship, how and when you advertise roles. We lose some of the European ideas, like ideas of proportionality when you look at legislation outside Europe, but essentially that the position is broadly the same. And what we hear from international employers is actually a huge amount of frustration. Why can't positive action be more permissive? Why can't we do more things to move this diversity agenda, to move this ESG agenda forward? And it's tempting, I think, to say we should look at the boundaries of positive action, we should make things more permissible. But actually, in talking to clients in practice, I think there's starting to be a realization that actually what they really want to do is prefer candidates for promotion or prefer candidates on recruitment. In other words, people who might not traditionally be seen as the best person for that role. And there's a realization, I think, that businesses need to start to look at this idea of, well, what is best? There's been a very traditional idea of who is the best candidate, perhaps based on qualifications rather than skills. And actually, there's probably quite a lot of inherent and subconscious bias in this idea of who is best. And there's starting to be a realization that probably instead of pushing against positive action, looking at a much more revolutionary approach to who and what we define as being the best candidate for a job actually might be a better way to push forward, push the pace and accelerate diversity, because it looks like positive action is going to remain pretty restricted across the world.
Thank you, Lucy. Very interesting. Philip, you shared data privacy group, and you have examined whether companies, because of ESG considerations, might move beyond what we would say a more traditional regulatory approach in relation to data privacy and data protection, and whether they will try to do better, actually.
Yes, well, in the majority of the countries that have contributed to the survey, the answer to the question is a simple yes. Many companies are more and more qualifying data privacy compliance and going beyond that explicitly as an ESG matter. And that's probably because we are becoming more and more aware of our personal data and of their whereabouts. We, the public, are increasingly expecting these to be carefully dealt with. And of course, it was not always that way. Some serious data breaches in the past years has sort of catapulted, if you like, privacy to the forefront of people's minds. Just to give you a few examples, many of you will be familiar with. There was a security breach in Yahoo, at Yahoo in 2017, that put the personal data of no less than 1 billion users into the hands of hackers. And it massively lowered the company value at the time it was bought by another company. Around the same time, I believe it was the beginning of 2018, a big scandal took place when Facebook had to admit that political consultancy firm Cambridge Analytica had misused data from 87 million customer accounts without their consent and even without their knowledge. And the reputation of the company dropped to a low point at that time. And thirdly, in Europe, as a result of the breaches of the GDPR that came into force in May 2018, fines were imposed by the DPAs of several countries. For example, a fine of 35 million euros was imposed on Hennes & Mauritz by the DPA of Germany in 2020. Apologies. A fine of 50 million on Google France by the French DPA, and 225 million euros was imposed by the DPA of Ireland on WhatsApp. These and so many other, perhaps smaller examples have brought data privacy issues on the agenda like never before, because it highlighted the potential costs and moreover the reputational damage as a result of misuse and theft of personal data. Of course, if you turn that around, then companies can improve their market position by distinguishing themselves by demonstrating awareness regarding data protection and compliance with data privacy laws, and even go beyond compliance. So the most important pillar of ESG in relation to data privacy seems to be the social pillar, because it focuses on the relations between a company and its customers, its employees, its partners, and its investors. Companies have, or at least they should have, a social responsibility to adequately protect the data they possess, not only of their customers, but for example, also of their personnel. So while on the one hand, personal data of customers can provide enormous value to the business, some say data is the new gold, but on the other hand, privacy is a social value that needs recognition and respect. Recognizing the need for privacy as a social value will increase a company's reputation, and in turn, that will boost the ESG score of a company. There is also an environmental consideration related to processing data, although perhaps less obvious, but still an important one to consider. And that is the ever-increasing amount of data that companies collect. The more data that is collected, the more storage is needed to store the data, and storing excessive amounts of data requires additional physical server space, hard drives, and other electronics to store information. And that leads to physical waste and increased energy output. Just give you an illustration. In the Netherlands, Meta, the mother company of Facebook, announced that it was going to place a hyperscale database in the north of the Netherlands. And then there was a lot of criticism against that, and opponents had calculated that this one data center would use twice as much electricity as the whole city of Amsterdam. And on a separate note, the Dutch parliament has blocked Meta's plans so far. So implementing privacy practices such as data minimization, in other words, how can we make sure that we only collect data that is absolutely necessary, can help companies to reduce their data footprint. Going back to the question, Sophie, not all of us gave the same feedback in answer to the question whether companies will go beyond compliance to privacy and data protection. There were also countries where the feedback I received was a bit more nuanced, like some expect that many companies see compliance with the GDPR as a big challenge as it is, because it's constantly in motion, the many EDPB opinions that have to be taken into account, the SECs that need to be updated, and what have you. Other contributors to the survey noticed that companies seem to be more focused in complying with privacy obligations because of the high penalty risks rather than to add value to the organization. So they use more a risk-based management approach rather than anything else. Some, and that's perhaps a bit cynical, some even think that in some cases there will not be an increase of focus by companies to move beyond compliance to privacy and data protection simply because companies don't want to. This is perhaps due to the convenience of many companies not to change existing processes, or companies just follow the data as the new gold approach. And this, of course, may limit willingness of some companies to do more than they have to do regarding privacy and data protection. One country that I would like to mention in particular, that is Ireland. And the reason is that many social media platforms and tech companies are headquartered there. The Irish Data Protection Authority is getting a lot of attention from other countries and from privacy campaigners. This publicity and profiling of data protection rights mean that data protection accountability, which is one of the principles of the GDPR, has a lot of public awareness in Ireland. And it is therefore likely that the public and the employees will expect companies to consider this a serious element of their ESG initiatives. So in other words, to conclude, Sophie, although it may seem as if compliance with data privacy regulation is a challenge enough as it is for many businesses, the majority of the contributors to the survey expect data ethics to slowly play an important role and increasingly become a business parameter. And the most important motivation for this shift is generally to generate trust between the company and its customers, generate trust between the company and its employees, and of course also, and most importantly perhaps, its investors and other stakeholders. And that's it from the privacy expert. Good, Sophie.
Thank you. Very interesting. Janusz, you're sharing internal investigations. So you looked at some ESG issues in relation to internal investigations. So can you share us a bit of your findings around the world, what you have discovered?
Yeah. What I can say is that general conclusion that can be taken from the survey in the field of investigation is that we see no provisions of law that would regulate directly area of investigations with regards to ESG field, except one area, health and safety regulations. In many jurisdictions, it is an employer's duty to investigate accident at work. This is something we all know. And this has a direct impact on ESG reporting. We know that safety at work is one of very important elements of non-financial reporting. And this is, of course, very important in certain industries like constructing industry, for example, or any heavy industry. So that was one general conclusion. But on the other hand, there were some general thoughts after the survey, and we think that, and this is obvious, that employers are organizations which are expected to follow the rules and values they publicly declare. And of course, this applies to all the rules and values that come within the framework of ESG notions. Yes. And we all know, we investigators, that business practice sometimes or sometimes often does not correspond with the values declared by the organizations or by the employers. And any disclosed breach or action that proves that the organization is acting contrary to the stated values poses a huge reputational risk for any employer. It has a significant impact on any employer reputation. And this, of course, applies to the area of ESG. And taking into account factors like recent developments of the whistleblowing clause, I'm thinking about EU directive and the process of implementation of EU directive concerning whistleblowing. And also growing awareness among employees of their rights. We expect a growing number of investigations related to the topics covered by ESG in general. For example, work and safety practices in the workplace. We expect investigations that refer to people management in general and organizational culture of employer. Something which was considered, we think, like 5 years ago as a soft violation or of internal policy, at present can be considered as a really serious violation. If we think about, for example, diversity issues in the organization or people treatment, I think all of us heard about, for example, toxic workplace. It's a relatively new notion. And we think that it can be subject of investigations in the future. There was one of the participants wrote that we may expect investigations preventive in nature. So we will be not investigating reported breach, but we will be investigated certain area to prevent future breaches. To me, it's not going to be an investigation. It's more or less an audit of the company in certain area. But that was one of the voices we had. Last thought is that if any significant breach is reported by an employee and the matter goes public, organizations and employers will be expected to conduct thorough investigations conducted by external advisors, as the way how they react to the revealed or disclosed breaches will have a significant impact on employer reputation in general. That's all from my side.
Thank you, Janusz. And then Lucy, number 2, from pensions. So you're from the pension firm. So obviously you looked at some pension-related matters. So yeah, I think your question, you had a look at whether pension schemes should consider social factors when investing. So if you could tell us a bit more about that.
Yes, of course. Thanks, Sophie. Yes, so as you said, we were gathering responses as to whether pension schemes must consider social factors when investing their assets. It was a very mixed bag of responses, actually. It was very interesting that despite the general increase in consideration and discussion of ESG factors globally and amongst and within the various practice areas, as we've just been hearing today and in the previous webinar, we saw a very mixed approach to the consideration of social factors, which I'll go through a little bit now. We received, I think, 13 responses, 13 different countries, and actually in many countries, including Hong Kong, Argentina, Australia, pension schemes are neither required nor even encouraged to consider social factors when it comes to investing their assets. There's just no legal requirement to do so at the moment. However, we have a larger group that may not have a legal requirement to consider social factors, but are actually choosing ESG criteria to consider when it comes to investing, and it's becoming increasingly popular. And Austria is a case in point for that. And similarly, it was noted from Finland in their response that they wouldn't be surprised at all if more detailed orders on the principles of investing in pension assets in the future came out. I think this is particularly because the Finnish occupational pension insurance companies have all actually voluntarily announced their commitment to ESG principles in their investment plans. So it seems to be a little bit of a developing trend. Another response from Greece said, again, there's no requirement to consider ESG factors, but they did stress that by implementing a framework of ESG principles, a company acquires and projects a very powerful image, both to its current performance, but most importantly to its sustainability, making it more attractive for both customers and investors. And they seem to be seeing this more. The company becomes benefits because the investors' interests increase, borrowing costs reduce, and it improves the company's profitability and general financial situation. There was a slight variance in Belgium, where pension funds are required to determine how ESG factors are considered, but there's not actually an obligation to take them into account. But again, they noted this is definitely an increased area of momentum at the moment, and they expect to see more. Similarly, in the US, again, no requirements at the moment, but there were proposed changes, I think, that were presented in 2021 that would look to address some of the ESG considerations. So you've got a kind of building group that don't have any obligations right now, but it seems to be kind of bubbling up that it's going to become, rise to the surface in the future. And then on the flip side to that, you have got some countries that actually do really have quite significant obligations in relation to ESG and investing in on the pension sphere. UK, Italy, Cyprus, Chile, lots of them have very significant obligations. In both the UK and Cyprus, pension scheme systems of governance must actually include considerations of ESG factors. And in addition, in both countries, pension schemes have to publish statements on how their investment policies take into account ESG factors. In Italy as well, the law provides that pension schemes in their investment decisions must take into account ESG factors. And Italy specifically mentioned that in respect of social considerations, they have to take into account the relationship between a company and its stakeholders in respect of human rights. So they flagged that as a particular point. In Chile as well, it's the board of directors that has to establish and consider social factors, which would include employee turnover, customer services, etc. And they have to consider those as modifying variables that might increase or decrease the issuer's internal credit rating risk. Jumping back again to the UK, we've actually seen here many new requirements imposed on pension scheme trustees in relation to ESG in recent years. They have to document lots of policies in relation to ESG, and from last October, the biggest pension firms have now actually got to do more reporting and governance obligations, and they've got to take into account risk and opportunities related to ESG, which has been a big change. And then smaller pension schemes are following this October. So there's been a big shift here in the UK. So as you can see, there's a whole range of different responses that we've seen, from very significant obligations to actually zero obligations at all. So although it's a varied picture, there does seem to be this growing trend that increasing interest in pension sphere of the social and ESG considerations is coming through, and I imagine it's definitely one to watch going forward.
Okay, thank you, Lucy. Thank you all for sharing those insights. And again, if you want to see the results and the responses per country, you can have a look at our dedicated webpage. Perhaps let's have a look whether there are any questions. Wait a moment. Perhaps Burkard, I have here one for you. If you're, would you see a move to soft laws like the OECD guidelines becoming more relevant in light of the ESG discussions? So what are your thoughts about that?
We do think so. We do think so that we should look more into, public international law and soft laws rather than the immediate implementation into our own laws. Because in a world where social conflicts, and when we talk in my field about restructurings, there is social conflicts will mainly be handled on media and social media platforms in the future, because that's the most accessible weapon in the hand of our counterparts, the unions and works councils, with the largest and immediate reach. Any blaming for not complying with laws that are not immediately your country law, but maybe a more softer level of laws where you as a company have committed to, or your country has been committing to. And the OECD guidelines are such a set of rules that all the US OECD countries have committed to, and also some of the multinationals have themselves committed to observing the guidelines, is just one set of rules that it's worth looking at it. And if I had been studying labor law 10 years ago, I think public international law was almost not on my radar scheme. But if I would study labor law in about 3, 4, 5 years ahead, maybe public international law will be at the focus of what we're doing. And just from its media and social media relevance. And what we've seen with the OECD guidelines is very interesting, because you can establish a jurisdiction, which is not really a court jurisdiction, but it's a governmental jurisdiction in each of our countries. In my country, it's the Minister of Economic Affairs, where you can formally file a complaint wherever you're located in the world, because against any company located in Germany. The minister will conduct an investigation, will have to conduct an investigation and issue a report. And while the investigation, you can hand in pleadings, but it's basically an informal proceeding of the government, the report will be made public. And we have seen cases, quite a number of cases now in Europe, where multinationals have been particularly addressed for the handling of union activism in completely different parts of the world, like in South America, basically. And we see cases, even in my own firm, coming in over the last weeks, where we are being asked to hand in documentation and defense alliance into these proceedings. And it's very interesting because it's completely unknown territory. It's not really a court proceeding. You're immediately back to the wall if it happens, because from a public standpoint, you will have immediate attention. And the issuance of a report that would basically blame you for not properly handling union activism outside of your own, maybe within your supply chain even, will be something that you will have to defend against and will be part of your evaluation when it comes to the big S of ESG. So yes, I think we have to think far beyond of what we see in our own textbooks and start looking not only like we do it today to the different countries around us, but also to the public international law side that will be mainly a focus of the people who are, maybe also targeting our companies in order to put pressure.
Thank you. I have here a big question. I think, Philip, it's one for you. It reads as follows. As a result of the pandemic, the concept of hybrid working has made its entrance in many companies. So hybrid working, which could be also seen as one of the pillars of ESG, because it refers to environmental, because we travel less, and also more flexibility for employees, which would then stand for the S. But of course, with hybrid working, the question is, and also, does this raise any concerns in the field of data privacy?
Yeah, as you say, the pandemic and the lockdown have clearly showed possibilities and advantages of remote working, also along the lines of ESG. So no more time wasted, no more commuting time wasted, no more pollution on the environmental side, but also on the social side, more opportunity to organize one's own working day. It means an improvement regarding the social pillar of ESG. But of course, the concept of hybrid working also triggers privacy-related questions, like, for example, how to monitor compliance with health and safety rules. Many countries have statutory obligations on the inside of the employer when it comes to a safe working environment, and that of course stretches out to remote working as well, and how to monitor that. Different countries, different answers to that question. Another question is how can employers register remote working hours? Because and also, for example, in the Netherlands, this is a statutory obligation. How can you cope with that? How can you do that? Another issue is how can employers safeguard cybersecurity from a distance? Imagine that people working remotely also have access to a lot of confidential company information. And what if somebody decides to have an afternoon at Starbucks and use the open Wi-Fi? Or what if somebody sits in a train with a laptop open and the neighbor is perfectly able to read whatever is written down on your screen? All those kinds of cybersecurity issues are also triggered by this concept of hybrid working. And last but not least, we see that also employers have a tendency to want to monitor the performance of their personnel as well. And the big question is, can they, or perhaps more importantly, should they? Yes, they can. There's software available to monitor the number of keystrokes that you type on your laptop. But the big question employers should ask themselves is, should we do that? Is that the best way of monitoring the output of an employee? I very much doubt that myself, actually. So that's just to give you an idea of the thoughts and the privacy related issues that arise when it comes to hybrid working, I guess.
Thank you. And if I can just say and promote another page that we have made, because we also have a dedicated page on the new workplace, and there we did surveys about issues of hybrid working and working time and whether we can monitor, etc., etc. So if you want to know in which countries you can do what, you can also find it on our webpage. I have another question here. I leave it open to anybody who wants to comment. And it reads as follows. What are the chances that ESG may go beyond the borders of those countries where consideration of these factors is obligatory by the initiative of multinational companies, but not local governments? For example, if an employee reports unhealthy work environment to the company's headquarters from the country where consideration of the ESG factors is still not obligatory. So any
Sophie, I'm happy to share some thoughts on this, because definitely one of the things we see in the UK, and actually it's relevant to diversity too, is that, and Burkard mentioned it right at the beginning, it's about supply chain management. And for international businesses, a breach of something that may not actually be a legal breach in the country in which it happens, but would be a breach, for example, in Europe, in the US, is a massive reputational risk. And so from a governance perspective, ESG governance perspective, in terms of health and safety, in terms of actually employee diversity as well, we're seeing when you do supplier contracts or supply chain management, much greater control, governance control of everything that's happening along your supply chain. You know, when I'm looking at outsourcing arrangements, we're looking to have audit rights on things like health and safety, working conditions, quite often audit rights on diversity. It's a bad PR story if, you know, everybody in a supplier business is, for example, white. There's no ethnic diversity, there's no gender diversity. So I think the answer to the question is, even where something isn't unlawful locally, because the world is so much more international, because businesses are global, from a governance perspective, ensuring that you are able to control and act on and try to avoid the kind of PR catastrophe of a problem somewhere in your supply chain is becoming more and more important. And when we're looking at outsourcing agreements and supply chain governance, I mean, very rarely now do I not draft people provisions that don't have audit clauses, the opportunity to audit, to try to avoid some of the problems. So I think it's an excellent question. Even when it's not unlawful locally, international businesses will want, from an ESG reputational perspective, to have some control. Others may have different views, but.
No, I think you always have to remember that you are also part of the supply chain. It's not only about your supply chain, you are also part of the supply chain, and others may look at you that even though that you may not be bound or not have committed to it, whatever, you may be judged on it and it will be the end of your business. So I think it doesn't really matter on whether your country is enacting anything or not, or whether you have committed to anything or not, because you're part of a global supply chain system and you'll be caught. So I think the question is excellent, but unfortunately the answer is no way out.
But I think it's more a matter of practice, whether you can put many regulations in your internal policies, but the question is whether you can execute them. Whether in the jurisdiction which is very different from yours, your contractual clause really guarantees that you will be able to audit your supplier. I think that's practical aspect of it.
Very true. I have another question. I'm also looking at the timer. I think we still have 5 minutes. Another question. Again, Lucy, I think it's diversity is a critical part of the S in ESG, but how does it fit into the G and the E?
It's a good question. Partly answered actually happily by the previous question, in that from a governance perspective in supply chain, we see diversity provisions. We see businesses wanting to understand what their suppliers' diversity is. I've seen there's a chain about you know, how you check everything. Often that's reporting, so contractual reporting requirements requiring your suppliers to report, for example, on their diversity to you. The other big governance aspect of diversity, which is becoming much more of a trend internationally, is reporting. So gender pay gap reporting against quotas. That's really a governance issue, particularly listed businesses being expected to report to shareholders on diversity related issues. E is really interesting, particularly in continental Europe, because certain beliefs are protected, and we're seeing more and more cases on whether environmental beliefs, so a belief in the climate crisis, for example, might be protected, and you might be protected from a detriment. For example, if you say, well, I'm not going to attend that work conference because it would require me to take an aeroplane, and I have a belief, in the climate crisis, whether those sorts of things would be protected. So I think with an emergence of really strong views about the climate crisis, people really materially altering the way that they live, we may see this idea of environmental beliefs being protected from a diversity perspective.
Thank you. I have another interesting question actually here. It reads, referring to the diligence efforts and the supply chain, what if your company deals with many different small suppliers? It's very difficult to check everything. And I think a comment is also large companies may be bound by the future corporate sustainability directive regarding due diligence, but not the small ones. So anyone, any views on that?
I mean, from a contractual perspective, so the work that I'm doing contractually, and I do a lot of this supply chain management, is often trying to do as little work as possible. So asking people to report and then meet objectives. So you'll have a reporting obligation from a diversity perspective on certain aspects. You'll report your diversity statistics, you'll report the number of women in senior level positions, and with a certain time frame, you'll be expected to have made a progress. And actually, sometimes if you haven't made that progress, it can result in a reduction in the fee or a financial impact on the supplier. So it doesn't necessarily require you to check everything, but it incentivizes the supplier, those smaller suppliers, to act in the right way, and shows you as a bigger international business forcing the pace of change. In other words, there being financial penalties attached to your suppliers. I mean, I'm talking about diversity because that's the hat I'm wearing today, but your suppliers not working with you on your journey to improve diversity. Others may have thoughts on different aspects of the supply chain.
No, I think this is absolutely right. I mean, we are not talking about something that will be implemented overnight, but you will see this in terms of conditions. You will see this in RFPs that will be sent out. Even if you have a large number of small suppliers, you will send out RFPs, and your RFPs will change, and they will adopt with certain criteria that you would want to have reported on a regular basis. I mean, if you look into this more like, what is going to change in the next 2 to 3 years, there will be dramatic changes even for small business, because they will have to report, and they may not be admitted to very simple RFPs. Yeah. And the way to protect yourself as a company that works with smaller business is by proper RFP.
Yeah. And then I have also a question, Lucy, for you. The other Lucy from the pensions. Are pension scheme trustees expected to become climate experts?
Well, from the UK perspective, certainly I can address that. We have, as I said, had a whole raft of new obligations on pension scheme trustees in relation to ESG. They've been come flooding through the door in recent years, and so there's a lot upon them to consider, and there are significant requirements in relation to reporting and governance, etc. But no, they are not expected to become climate experts or scientists themselves. They are still ultimately responsible and accountable for ensuring that they comply with laws and regulations, but it's on them to kind of reach out to advisors and investment consultants and to ensure that they're best placed to comply with what they need to do. There is a whole wealth of guidance available to them here in the UK that helps kind of guide them through the process. So they need the relevant training, but they don't necessarily need to be climate experts.
Okay, thank you. Wait, I'm just looking, see another comment here. So I think it relates to the previous discussion we had. So the comment is, but at what point does that become an abuse of monopolistic power, which is in any other context? Which it is in any other context. Any comments? Burkard.
I think if you are following obligations under your law, this is not an abuse of power. Yeah, I mean, what you need to make sure is that you ask legitimate questions that are deemed to protect you against whatever are the requirements under your law. And then even if you are otherwise a monopoly company in your business, this is not the exercise of an illegal, can never be the exercise of an illegal monopoly power. I understand the question though, because of course there may be some political bias with it, you know, like if you like overstretch it into a political side, and then it may be, these are the discussions that we're seeing with some of the larger media multinationals these days, where that's a question of anti-monopoly law, but not for a general business practice.
Okay, I think there are no other questions anymore. Any other question? Okay, and also looking at the time, so I think we used all our time. So then I can only thank our panel for their insights and also the very interesting discussion, and also our audience. Thank you very much. Also, thank you for asking all those questions, which gave rise to interesting discussions. So, and I hope you have all a very nice and pleasant rest of your day. So thank you very much, and bye-bye.